Okay, so in this module, what we're going to do is we're going to be taking a look at some of the core tenets of effective legal drafting. And we're going to look at each of them in some detail, and I'm going to give a number of examples. In the next module, we're going to look at some actual practical examples so that you can start to see these working as you actually open your eyes to their existence and see how they work in the real world. But for this particular module, I'm only going to give a couple of examples, and principally I'm going to talk about the what and the why rather than the how. So, what is the first one we're going to tackle? The first one we're going to tackle is purpose. Effective legal drafting always has a purpose. Now, it doesn't really matter what you're writing at this particular point, whether it's an email, a tweet, an article, a submission, a pleading, a contract clause, or a letter. You are going to have a purpose in mind. Why do we care about the purpose? Well, we care about the purpose for a number of reasons. We care about the purpose because as lawyers, we have a tendency to waffle on. And we get caught up in working through our reasoning process. And so what happens is, if we're drafting, in particular, a complex letter, if we're drafting a complex letter, then what we do is we have a tendency to take that letter and put everything in our brain on the letter. What's that look like? It looks like this. Dear John, you asked for our advice on whether you have breached the contract you had with Mary. And then we do a heading. Information you have provided us. You provided us with the following information: 1, 2, 3, 4, 5, 6. Our advice is conditional on this information. If you have any other information, please let us know. Number 2. Please bear in mind that our costs associated with this advice will be whatever. And then we do another heading. Here is the background information as we understand it, based upon the documentation and information you provided. On this date, this happened. On that date, that happened. On this date, that happened. And then something else happened. And then something else happened. And then the thing happened that you think might have been the breach. And you told us this, that, and the other thing. That's our understanding of the effective chronology of information. Now, so far, we've had 3 headings, and we haven't actually started to address John's question, which was, has he breached the contract? All we've done so far is we've told John what he's given us, what our costs are, and then told him again what he already told us. But this is a standard way of starting letters. So I'm sure you've seen a lot of letters like this. You may have even written them. We're going to come back to that in a practical example. But so far I'm just showing you that in the first 3 headings of a letter, we have yet to even begin achieving the purpose for which the letter has been written, which is to provide advice. And then we might do another heading. What is the law? Here is the law. Section whatever of the thing says this. There are a few words in this. You need to meet the following elements: 1, 2, 3, 4, 5. Each of those elements has certain law associated with it, and here are the cases that we have reviewed. Such and such says that so and so should be interpreted this way. A versus B says that such and such should be interpreted this way. There is contention about the third word, and it's been interpreted in a number of different ways depending on what month of the year it was. And in respect of the last word, we've been unable to find any cases, and so we looked up Google, and it tells us that the word means this. Those are the elements of the thing that you've asked us to look into. So far, still haven't gotten to the purpose. We're still just outlining our reasoning. But yet, this is still the assignment method of providing advice to a client. What do we do next? As a rule, what we do next is we go application, don't we? We've said what the facts are. We've said what the question is, so we know what the issue is. We've said what the law is, and now we apply it. In your circumstances from sections 1 and 2, if we apply them to section 4, then we arrive at the following conclusion. This has happened, that hasn't been ticked off, this element is met, this element isn't met, and there we have it. And then you might put the section with the actual answer, conclusion. In our view, you have breached the whatever with the thing. And then you go to consequences. Section whatever of the so-and-so says that you may be liable to a penalty, or a breach of contract may attract the following potential damages. They might include A, B, C, D, or E. Various other things might happen. You might fall and hit your head tomorrow. Have a nice day. Yours faithfully, firm name goes here. That is a very common form of letter, but let's look at it from the point of view of purpose for a minute. What is the purpose of the letter? Now, I've started with the fundamental premise that the purpose of the letter is to advise the client. And so you say what the client has asked you to do, and then you advise the client. Now, if that was the only purpose of the letter, then it would be done in 2 paragraphs, wouldn't it? Because the client doesn't care about the reasoning, probably. They just want the answer. They didn't say, please give me a list of all the relevant sections that might apply to my circumstance. They said, am I in trouble? Or am I not? And then they might want to know the extent of the trouble. But in general terms, other than sophisticated clients or clients that you are aware have a particular desire to Google everything you say to check whether you've got it right, what you find is that clients just want the answer to their question. And so if John has asked you to advise him whether he has breached a contract, you could answer that in 2 paragraphs. So there's clearly something more going on here, because the purpose of the letter, if it's just to advise the client, it's not necessarily been achieved very succinctly. And we're going to come back to that in one of the other core lessons. But what has happened is that we have introduced a secondary purpose, haven't we? Which is butt covering. We have taken the fundamental purpose and we have turned the majority of the letter around so that the purpose that's in fact being fulfilled is that we're covering our own risk by saying what he gave us, by articulating the question again, by saying the information as we understand it, by setting out the chronology, by setting out the law. We're trying to have plausible deniability, because if John reads that letter, which he won't, and I'll come back to this, but if John reads that letter and it turns out that one of the critical facts was incorrect, then we have covered ourselves because we said our advice is conditional on this information. But our purposes and the client's purposes have become misaligned. And this is why purpose is so important. Because in the overall context of client service, purpose is a very important starting point if you're going to write an advice to a client in particular. Other communications, yeah, sure, they might be a little bit rambly and you might suffer very little. But advices in particular, where your client has given you a very specific question and you have a very specific answer, if you take 5 pages to get to the point that your client cares about, then you're going to get yourself into trouble, because they're not going to read it and they're going to call you and ask you what the advice is. They're going to say, I don't want to read 5 pages of information. And this was drilled into me very early on in my career, and it was drilled in very well. And there is a delicate balance that you need to adopt between the different and sometimes contradictory purposes of a letter. I accept that risk management is a necessary corollary of legal practice, and that sometimes you do need to have those sorts of caveats in your letter to ensure that you're doing your job properly, but also to ensure that you don't get yourself sued later. However, can you find a way to do it without disrupting the client experience? Yes, you can. And we're going to come to that in our practical examples later. But for now, what I want you to understand is that a document that you are producing does not necessarily have only one purpose. And that if those purposes are contradictory, then you're going to need to figure out how they should work in tandem so that you are achieving both, not just inadvertently finding your way onto one. So let's look at it from another perspective. We have looked at purpose from the perspective of client communications and how annoyed clients are going to be. And as I said before, clients judge you on subjective elements, not objective elements. The objective element is whether you were wrong or not, and that generally won't be known to the client until the decision comes down from the court or until something goes horribly wrong. But for now, you've got the client marking you. What about if you have a judge marking you? What if you go in with a submission and you haven't necessarily drilled down on the purpose of your submission, and so you just say a bunch of stuff? Will the judge get the point you're trying to make? Will the judge read the material and go, aha, I get it. This is the point that you were trying to make. What is the purpose of your submission? You're trying to persuade the judge of something. But what? If you go in with a rambling, untargeted submission that is purposeless and that doesn't keep coming back to that principal purpose, then you're going to be unpersuasive. Similarly, in contract drafting. If you try to prepare a clause, and if you try to get things going in terms of a clause that becomes overly complicated, is it going to achieve its purpose? You see this with standard contracts in particular. You see them in particular in the building and construction industry, but you see them more and more. Someone has gone in trying to draft a simple clause, and it gets longer and longer and longer and longer and longer until it is so incomprehensible it no longer achieves its purpose. Because contract clauses can have a number of purposes. Some of them are protective. It is designed to let the other person know that they ought not do something. Some of them are for use as a sword. What happens if something does go wrong? Some of them are protective in the sense that they protect you from risk. And there are various other purposes. But if your clause has become overly long and rambling, it is not achieving its purpose. So, before you produce any article or any document or any form of writing of any kind, you need to sit and think, what is its purpose, or what are its purposes? And you need to have them front and center when you're producing your document. Because if you don't have the purposes in mind, you will end up with an untargeted, non-specific, purposeless piece of writing. And you don't necessarily need to spend an hour. If you're drafting a short letter, you don't spend 3/4 of an hour thinking, no, what's the purpose of this letter? I better get this right because Chris said so. You will become accustomed to doing it almost automatically. Why am I writing this? What is it designed to achieve? And then everything you write can be honed in on that. We're going to see this in practice soon. So don't worry about necessarily understanding all of this so far as what it looks like in real life. We're going to come to that. But for now, have a purpose in mind before you start producing something. It will inevitably help you to refine your writing, almost in and of itself. That's it for this lesson, and I'll see you in the next one for our next core strategy.